matter to come before the court this morning is Marvin v. Pflaum, I believe, versus the Southern County Animal Shelter. Each party will have 15 minutes in which to present their case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know when you come up to the podium. I keep track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have ready to brief and we're ready to proceed when you are.
Thank you so much. May it please the court, my name is Jeff Holland. I'm the attorney for the appellant in this case, the Pflaums. Your Honors, this is and I would like to reserve time at the end.
How much?
5 minutes if you don't mind. Thank you. This is a case that it was a dangerous dog proceeding. So this is a statutory proceeding in which there is a legal term of art called a dangerous dog that is specifically defined by statute, and there is a specific process by which we go through to determine whether or not a dog is deemed to be dangerous or not deemed to be dangerous. And there are only very specific situations in which a dog can be deemed to be dangerous. It might not be what an ordinary person might think, but it's specifically set forth in statute. And in this case, it really applies to an animal that caused injury to a person where there was without provocation. And that has to be proved by clear and convincing evidence. That is the state's burden in this case. And so what we had in this case, essentially, the facts are fairly simple, that on July the 13th of 2015, there was a dog, the dog's name was Edwin, and the dog and another dog whose name was Rudy got in a fight. And during the fight, a third party came by. Her name was Trixie Clemenshaw, and she decided to intervene in the fight. So she stuck her bare arms into a dog fight, grabbed the collar of the dog named Edwin, and she was bitten during the fight. After the fight, she immediately reported that to a dog warden. She advised the dog warden that she punched the dog, and that it was after the punch of the dog that she received the dog bite. During her testimony, she said that she didn't have any current recollection of whether or not she punched the dog, but she did say that she did remember telling the dog warden that she did punch the dog, and that she was trying to be fair and accurate at the time, and that she thought it was the appropriate thing to do. So the question really is not whether or not Edwin is a good dog or a bad dog. It's not whether or not Trixie Clemenshaw is a heroic person because she stepped into a dog fight and tried to break it up. And it's not whether or not Trixie Clemenshaw was foolish for sticking her hands into a dog fight. The issue is whether or not the state was able to prove by clear and convincing evidence that this was an unprovoked bite. It was not provoked. So what happened was we had a hearing. We had it in front of the magistrate, and evidence was presented. There were some items that were stipulated, a number of items were stipulated. And the magistrate made a ruling and said, because it is unclear as to whether or not, she made the report that she punched the dog, and it's unclear, I'm not sure whether or not she punched the dog or not, but the burden is on the state. And if she punched the dog, that's provocation. Because we also had the testimony of a dog behaviorist who specifically examined this dog, determined that this dog is generally not the kind of dog that would bite without provocation, and that a punch to the nose would certainly cause enough provocation to create a bite. Furthermore, indicated that by the nature of the dog, that if it was a more aggressive bite, one that was not caused by provocation, that the dog would have continued. It wouldn't have been a single bite release. So that was the decision that the magistrate made. The state filed a timely objection to the magistrate's ruling, and then the judge took a look at it. The judge reversed the magistrate's order. I asked the Court of Appeals...
What standard of review do we look at in regard to that? This is a little unusual situation because usually we have the situation where objections are filed and they're overruled, and then the appeal comes about. So here's the situation where the judge actually obviously didn't adopt the magistrate's position and made his own independent determination. What's our standard of review?
Well, the standard of the review for the magistrate or for the judge is is to look at all of the, all of it de novo. So, and there.
What is our review of the judge's decision?
Well, your review is whether or not she made a clear error. So, she made an error in the law, is what we're saying.
So,
If she makes an error in the law, according to her reasoning and according to her findings, then you can reverse her decision.
so you're saying it's a legal question, it's a de novo review?
Yes.
So we're not to give any kind of deference to the trial court here at all?
I think that is correct. Yeah. And the.
Based on the issues of law?
That's correct. And you know, there's really no issue as to the facts. The magistrate agreed to the facts. I think that the judge agreed to the facts. The judge didn't come back and say the magistrate made errors in the facts. The magistrate came back, or the judge came back and said, I disagree with the finding of the magistrate. What happened was, I think that the judge took a look at this and said, gee, that seems like a dangerous dog to me. And the judge's reaction was more of an emotional reaction, and you can see it in the decision. What the judge said in the judge's ruling was, Edwin, without provocation, grabbed Rudy. Well, Rudy's the other dog. There's not a legal issue as to who started the dog fight. Now, the legislature could have said that a dog that starts a dog fight with another dog is a dangerous dog. They didn't. The legislature could have said a dog that causes an unprovoked injury to another dog is a dangerous dog. They didn't.
But the trial judge looked at it also and said, without provocation, meaning that the dog was not teased, tormented, or abused, and said there's no evidence here that the dog was teased, tormented, or abused.
But the issue, there actually was, and I think that they acknowledged that, but her analysis was that the dog was aggressive. If you read the magistrate's decision was this: we have a statute that requires clear and convincing evidence that shows that the bite was not provoked. That's what we have. And since it appears that she said that she punched the dog, now she's saying she doesn't remember if she punched the dog. We may never know if she punched the dog, but it is unclear, it is not clear and convincing evidence that there was no provocation.
Well, I guess what I'm getting at is the judge says Ms. Clemenshaw clearly did not tease, torment, or abuse Edwin.
Yes, and then the next sentence is she was taking action to save another animal.
Mm-hmm. Where's the evidence of teasing, tormenting, or abusing?
The punch of the dog.
So the punch of the dog is what? Is that teasing?
It is not teasing.
Is it
It's
tormenting?
Yes, it's tormenting.
It's tormenting.
Yes, Your Honor. There are 3 words, and there are 3 words there for a reason. And counsel pointed out that there has been some case law on what teasing is. Teasing, there is some case, there's very little case law on any of this, but there is some case law to suggest that teasing is something that happens more than once. There's certainly case law to indicate that abuse of an animal indicates a wrongful action and is a greater degree than tormenting. And tormenting is a significant pain. There's only one reason why you would punch a dog in order to break up a dog fight, and that's to get the dog's attention with pain. That she was trying to cause the dog pain in order to break up the dog fight, and indeed the dog fight broke up. So is she a hero? I don't know. Was she foolish? I don't know. It doesn't matter. The point is that the dog would not have bitten her but for, or we don't know even whether the dog would have bitten her but for the punch. But what we know is that the state did not prove by clear and convincing evidence that but for the punch, the bite would not have occurred.
But for the punch, the issue between 2 dogs terminated.
We don't know why the 2 dogs, we don't know if she had sat back and done nothing, whether the dogs would have had a tussle and it would have broken up on its own. I guess the other thing I want to mention, which is I think was an error that was made in the appellee's brief, was they said that Ms. Clemenshaw punched with her non-dominant hand. That's actually not true. She testified that she used her left hand to grab the animal's collar, which means her right hand would have been used for the punch, and that's a transcript, page 16 and 17.
But she didn't, really said she didn't even remember punching the dog.
What she said, she didn't remember whether or not. But what she did say was she said that I reported it immediately thereafter to the dog warden. I was trying to be fair and accurate, and I did tell him that I punched the dog. And I believe that I should have punched the dog. I just, as I stand here today, a year later, don't remember because it all happened very quickly.
Was there any testimony as to which hand was dominant?
Yes, she said that she was right-handed, and she said that she grabbed the dog's collar by the left collar. I don't think that that really matters, but it was something that was raised in the appellate brief.
It does go to your point about punching a dog, whether that's tormenting, if the definition is causing considerable pain.
Yes, and I guess you have to.
I mean, if you just swat a dog, I don't know that you can argue that that's.
Well, even if you were to she didn't use the word swat, she used the word punch, but even if you were to swat a dog, let's say to scold a dog. Dog, you peed on the rug, I'm gonna give you a swat. You're not trying to tap it on the shoulder to get its attention. You're trying to give it a little smart, a little bit of pain, in order so it knows not to pee on the floor. So, in this case, she's trying to break up an ongoing dog fight, and the issue is not how hard did she punch? Was that proven? No. But the burden of proof is on the state. And
You have 4 minutes and 30 seconds left.
how much?
4 minutes and 30 seconds.
I will reserve that. Thank you so much.
Good morning. May it please the court, my name is Colleen Sims, and I am counsel for Summit County Animal Control. With respect to the last question posed by the judge, which I will paraphrase, is punching a dog tormenting a dog? And I certainly think there are situations where punching a dog would be tormenting a dog, but that does not apply in this case.
Would it be more than one punch?
It would probably be more than one punch. In this situation, it appears that there was one strike, possibly one punch to the dog. But that did not happen in isolation. Trixie?
Right. Let me ask you, I'm sorry, I can
Sure,
just jump
no.
in, but I think you would agree that if somebody just goes up and punches a dog, and the dog bites them, that would be without provocation.
I would agree with that, Your Honor.
That would be with provocation, is what I'm trying to say.
Absolutely.
So really, isn't the problem here because the dog will engage in a fight?
I'm sorry.
Isn't the problem here the circumstances that the dogs were engaged in a fight?
I believe that the judge found, and I'll address the standard of evidence, but I believe the judge found that the events were started by the dog Rudy in
So
this
the
case.
provocation was the dog fight.
Yes, and I believe there was even a stipulation that the dog, Edwin started the fight.
But what does that matter? What does that matter if you're just looking at the statutory construction here? And I am interested in your standard of review, but if you're just looking at the statutory construction here, and look, I'm not placing value judgments on anything here. We just have to look at the statute itself. And the statute itself doesn't talk about if dogs are engaged in a fight, or if one dog's a bad dog, or another dog's a good dog, or anything like that. Or if the dog is aggressive toward another animal. It talks about what you're charging here is biting without provocation.
And I believe in looking at the circumstances of this case, and I think there's an argument, you just look at her actions, but you have to look at she's reacting. Her actions are based on a reaction, based on what she's seeing at the end of her driveway.
Right, but does it really matter why she did what she did? Because she isn't on trial. I mean, nobody's saying, I'm sure she had the best of intentions in the world. You know, I can't even imagine jumping in between two dogs. That sounds pretty heroic, but does it really matter?
I believe it does matter because I think it shows that she was acting without provocation, which is essential in
What does it
finding.
matter what she was acting? Isn't it the dog?
And I would argue with the dog is that he's not just walking down the street and being punched. He, through his actions, has attacked another dog who did not attack him, and had the dog in his mouth when Trixie Clemens-Shaw struck Edwin.
Pete, I'm sorry, what do you want to say about the standard of review here?
I believe it is abuse of discretion, and I think that the closest case on point that I have in my brief is Spangler versus Stark County Dog, which talks about a civil judgment which is supported by competent, credible evidence may not be reversed. I believe that is the standard. It's more than de novo. Certainly the magistrate's decision is reviewed de novo, but I think that in this case, Judge Coates issues a very detailed decision of why she found that Edwin was a dangerous dog. And I would argue that the standard is abuse of discretion rather than de novo.
Do you think this is a legal issue?
I think it is a mixed, applying the specific facts in this situation to the law. I have reviewed the cases cited by the appellant from a variety of jurisdictions, and I think other states probably struggle, like with our state, that there isn't always a clear definition of what constitutes abuse, what constitutes provocation. In all the cases cited, I did not find, I only found one case close to this situation. There were a total of 10 dog bite cases. There was one case that cited many other cases. And there was only one case where a dog had actually was holding a bird in its mouth. In all the other cases, the dog isn't attacking anything. The dog may be trying to get to its food. The dog may be trying to chew on a bone. But there really wasn't a case analogous to this one where the dog was in the case cited by the appellate, other than there was a Labrador retriever with a bird in its mouth. But I would even argue that's not completely analogous because a Labrador retriever is trained to bird hunt. I don't think there's any evidence that dogs are trained to attack other dogs legally outside of dog fighting.
Dogs do get into fights.
They do. And in this case, as the record indicates, the owner was attempting to stop his dog and was unable to.
What did the evidence say that he did? I think you said in your briefs that he, were the dogs still on leashes?
To my recollection, I believe the dogs were on leashes, but
Because nobody was charged without having the dog on a leash, right?
no.
Okay. So was there specific evidence in regard to that?
The evidence that I recall is that the owner was giving verbal commands to Edwin, but Edwin was not complying with the owner's verbal commands.
But there was no testimony that they jerked on the leash and pulled the dog or anything?
There was no testimony that the owner had done anything physically to stop the fight, but that verbal commands were given, and then the owner of Rudy was screaming for help. There is one case, and it's not directly on point. A lot of these relate to liability of personal injury suits, which isn't exactly on point here. There is one case that I cite wholly. I apologize. The one case I cite, Mason versus Hallowell, on page 6 of my brief, where there was a situation where a dog had attacked another human being, and a person hit the dog in the head to release that grip. So again, I don't think her actions show that she repeatedly used force against this animal. This was one strike, one punch, to get the dog to release, and she got the desired result. The dog released the animal, and instead bit Miss Clemenshaw.
Was there evidence that the dog was focused on her before the punch?
No. The dog was focused on Rudy, who Trixie Clemenshaw had known for quite some time. She was next door neighbors with this dog. And I believe it's not too far of a stretch to, obviously her neighbor had strong affection for her pet.
Let's say that she never got involved and Edwin killed Rudy.
Edwin would be labeled a dangerous dog, and that was one of the things I pointed out in the objections, when I objected to the magistrate's decision. Basically, she prevented the dog, I believe there's evidence to show that.
So they would have had the same hearing to determine whether or not Edwin was a dangerous dog, even though there was no person
Now,
injured?
correct, and Rudy, the smaller dog, did not die, but having the dog in its mouth and shaking it like a rag doll, I don't think it's beyond probability that the dog could have.
Was there any evidence about that?
Nothing more than what I am saying, but she was afraid, I think, that the dog was going to be seriously injured, if not killed, if she didn't.
Was there evidence in how injured the dog was after the encounter?
There was not. But there was evidence that the entire dog was in Edwin's mouth. And that he was shaking his head vigorously. And again, the evidence, this dog is off its own property. It's at the edge of Trixie Clementshaw's driveway.
That's on a leash.
Yet there's no evidence that there was any leash violations.
Well,
Was
there's
the dog on a leash?
Sitting right here, right now, I believe the evidence supports that the dog was on a leash. I don't recall there being any leash violations.
Wait, in other words, you don't know. I don't mean to be.
As I stand here today, whether,
It's okay to
Edwin
say
was
you
on
don't
a
know.
leash.
We
I
don't
don't
hold it against
know.
you.
okay,
So
fair enough.
because we'll review the transcript to see if there was any evidence presented on whether there was a leash or not. It's okay. Like I said, I don't remember everything either.
So with that, I conclude and rely on the brief submitted. If there are no other questions, I will waive the remainder of my time. Thank you.
Attorney Holland, you have 4 minutes and 30 seconds.
Thank you so much. You know, it's really tempting to speculate on this and decide whether or not the dog, I mean, I would love to be able to say the dogs would have broken up the fight had she intervened or not. Ms. Sims might say it's tempting to say that the one dog would have killed another one. That's total speculation, and it's not in the record. What we know only is this. The dog was, and to Judge Teodosio's question, the dog was not focused on Ms. Clemenshaw. There's absolutely no evidence that the dog had any interest in Ms. Clemenshaw at all until Ms. Clemenshaw provoked an attack by punching the dog. That's what happened. If she had never entered this fray, she would have not have been bitten. She provoked the response. Now, was she heroic? Yes. Was she foolish? If it was my daughter, I would tell her, you're foolish. Stay out of it. The dogs will break up the fight probably on their own, but you're going to get hurt. So one of the things that the trial court said is, oh, the legislature couldn't possibly have wanted people to be dissuaded from getting involved in dogfights. Maybe that's exactly what they wanted. I mean, there are strange things about this statute. If a dog kills a cat, no harm done. It's not a dangerous dog. If a dog tears the neck out of a horse and kills it, it's not a dangerous dog. It's only very, very specific issues. And I would refer to Pulley versus Malik, which is referred to in Appellee's brief, which specifically talks about what is torment. And in that case, it was a dog, somebody who is, with every good intention of the world, went to pick up a dog that was severely injured. They picked up the dog that was severely injured, and guess what? The dog felt pain and provoked a bite from that dog, and that was considered to be torment. It has nothing to do with whether or not anyone had good intentions, bad intentions, they were altruistic, they were busybodies. What we know is this happened very fast.
Do you remember if there's any evidence in regard to the leash? I mean, we'll read the record.
I don't remember, and I don't think, I think it's a red herring to be concerned about it, because I don't think it's an element, and I don't think that it is mentioned in either the magistrate's or the judge's ruling.
No, I get your point, but I guess both sides have talked about what the owner did, and.
I actually have it, because I don't think that it's
Okay,
relevant.
all right, well then, the appellee has talked about what the owner did.
Yes.
And I'm not sure if I read it either in the, either order, but regardless, it might have been one of the orders. But regardless, the point was that supposedly the dog wasn't listening to the
Yeah,
owner.
sure.
And I'm just wondering what steps were taken, what evidence there was as to what steps was taken by the owner.
I
It's
don't
a little
remember.
bit different than just orally saying, now stop that, or jerking on the leash and saying, I said, stop that, that kind of thing. So I just wondered if there's any evidence of that.
I think it's fair to say that if both dog owners were properly controlling their dogs, they probably wouldn't have gotten in a dog fight. I don't think that that's the issue before the court.
Well, that wasn't my question either.
Yeah.
My question was there a leash involved?
Yeah, I know.
That's all I'm asking you.
I don't remember, I don't remember either.
Okay, that's
I don't
what I'm
remember
saying.
either. And I
And
think I
won't
remember,
use you either.
I think I remember, but I don't want to say it if I don't really remember. So I
That's
don't wanna-
exactly right, that's fine. Well, then we can move along, go ahead.
Yeah, the other thing I just wanted to mention is that, it's really tempting to say, who started the fight? Was it the right thing to break up this dog fight and so forth? And it was the right thing to punch a dog if it's in a fight. I guess my question is, what if the dog was getting into the cupboard and it pulled out a box of cereal and was eating the cereal peacefully? And somebody came along and punched the dog because they wanted to stop it from eating the cereal. Now you could say, you really got to stop dogs from eating the cereal. But if the dog turns around, maybe you're a guest in the house and you punch the owner's dog in the nose because you want to try to stop it from doing something bad. Maybe it's in the cat litter box, some bad thing, and you punch the dog. And then the dog turns around and you bite. I don't think any of us would hesitate for a moment to say, oh, they provoked that reaction. And when you read the judge's opinion, because the judge's opinion is not one sentence in isolation. It is clearly a judge who looked at this and said, it just doesn't seem right to me. It just, from a common sense point of view, the dog just kind of seems dangerous. But the statute, the word dangerous dog does not mean dangerous dog in the colloquial sense. It could have been a type A dog, according to the statute. It just is, it's a legal term of art. And what the judge says in overruling the magistrate,
Attorney Holland, you can read that, you're out of time. But we will read the judge's decision.
I appreciate your time and attention, and thank you very much.
Thank you very much. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted to our website and at Supreme Court.